Hi friends, this is Chet Gallagher again. We're continuing some brief instruction in these brief audio-video presentations to try to not only educate people but encourage them to see how significant this time is that we've been called to. I want to talk a little bit now about some constitutional arguments, very key to understanding. If you've not heard this before, if you're not aware of what the Constitution has to say, this is not intended to be an in-depth discussion at all on the Constitution, but just on specific issues, defining, for example, what the Supremacy Clause really means. In brief, the Supremacy Clause, that is when you hear someone say, well, the Supreme Court has ruled and therefore it's the law of the land because of the Supremacy Clause. It's important to understand, and any student of the Constitution should have this appreciation, that the Supremacy Clause applies to the Constitution, as well as certain powers that are articulated, enumerated powers they're called, to the three branches of the government. And those three branches of the government have certain jurisdiction and certain places where they can rule, certain subjects and topics that they can rule upon, as far as creating a standing army and taxes, and we could just name some of those enumerated powers. But the most important thing for you to understand regarding this attempt by the United States Supreme Court on June 26 of 2015, this attempt, emphasis on the word attempt, as they opined their definition of what marriage was to be now called and included. That marriage being within the context of not only a man and a woman, but now also whatever we want it to be. In this case, we're talking specifically about homosexual unions, the marriage between a man and a man and a man and a woman, an abomination before a holy God. Is the Supreme Court wrong? Yes, they're wrong. They're wrong first because their definition of marriage is directly in conflict with the law of God, upon which all laws are to be based. And any law that does not mirror the law of God, but rather spurns or impugns the very law of God, must be opposed by a righteous people, especially those who've committed their lives to serving Jesus Christ as Lord. So the Supreme Court is wrong first on that very important issue. The second thing that we need to bring to your attention is that there is no jurisdiction for the Supreme Court to have legislated in this way. As a matter of fact, both Judges Roberts and Scalia, Judge Scalia recently, just in the last 48 hours, has died. But before dying, one of the greatest dissents that he had written was regarding this law of Obergefell v. Hodges, this homosexual marriage bill. And he was right, just as Justice Roberts was, that this was super legislation from the bench, from 9 unelected judges. Courts cannot make laws, yet they presume to have jurisdiction when there is no enumerated power, no articulated power designating domestic marital affairs and family affairs to the Supreme Court. And what the U.S. Constitution makes very clear is if these branches of government do not possess, act upon, rule, and legislate within the context of these enumerated powers where they have legislative powers, which the court does not, then those powers automatically become powers possessed only by individual states. So clearly, this is wrong, not only on the moral grounds that we've articulated, contrary to the very Word of God, to the Holy Scriptures, the basis of law, but also the jurisdiction that they have overreached, encroach upon the very will of the people. And this is why it calls for interposition, which is going to be the topic of our next time together.